Hello, hello, it's me again, the snarky juror. This is take two. I'm recording this very early in the morning, like 2 a.m., because I'm trying to catch up. And I did a boo-boo, the big one, but fortunately it was only 38 minutes into the recording. Let's see if I can do it right. I'm going to put you there. We don't need that, but we do need this. So I'm in the corner. We are now back on Court TV. Court TV. Yesterday, the prosecution, I think I've got this all right. The prosecution put on 8 witnesses. So number 9. The jury is just now entering. And the first witness will be Alicia Byers, which is Ashley's mom.
All right, y'all can have a seat. Good morning, everybody. Welcome back.
Good morning.
Check and make sure we got the right notes in the right place. Those are yours. Check your pens. Make sure they still got plenty of ink. All right. Good morning, everyone. I just want to make sure that nobody began discussing the case amongst yourselves or started deliberations. Nobody discussed the case last night or this morning with anybody outside of the jury. Nobody approached you or talked with you or tried to influence you in any way. And you didn't do any research on the people, places, things, or legal topics we've heard anything about.
No, sir.
All right, everybody says no. Thank you. When we finished up yesterday, the state was still presenting its case. So, state.
State calls Alicia Byers.
Yeah, it's Byers. That's her mom. Why is this not advancing? Oh, great. What is this?
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Oh, because I have.
You can allow your voice right into it. It'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in.
Yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you.
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes.
And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes.
I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Santz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Santz?
I'm not sure.
Okay.
I don't know.
Okay.
Why didn't she ask John when he was on the stand?
And you and your daughter obviously are very close. You lived together, just the two of you, right, for a
Yeah.
while.
Mm-hmm.
And then once the baby was born, the baby lived there with you,
Correct.
correct? Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mm-hmm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay.
He had found his dream job.
So he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was moving, packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
It, I think it,
If you don't
the
know, that's
U-Haul
okay.
was getting there when I was leaving.
Okay.
Yeah.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your
Yes.
driveway? Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. And when you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yes.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left?
Mhm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading.
Yeah.
No, I will roll.
You've been in contact with her basically every day, correct? Since
Not
the-
initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever,
Putting words,
during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
I'll sustain.
Okay. So at the time that the shooting happened, she didn't tell you what happened,
No.
correct?
We've never talked about it.
And
No, overruled.
to this day, you've never talked about it?
No.
Thank you. No further questions.
I don't understand why they put her on the stand. Makes no sense to me.
Good morning, Ms. Byers.
Morning.
Are you nervous?
Yes, very.
Scared?
Yeah.
All right. Let's try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay. Thank you.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes. We're very close.
And would you try to spend time with her?
Yes.
Would that include you taking her somewhere on a regular type basis?
Yeah,
Would that be to the park?
yes.
And tell the ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because the park does not have very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or
Oh, yeah.
minimize it, it'd be later in the afternoon,
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
almost as bad as it is now.
Right, exactly.
How far away was the park?
It's a short walk. I mean, we'd always walk over there. So I
Mhm.
don't know, take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like you
No,
did
but
regularly.
Yes.
Give me a moment, Your Honor, please.
sir.
I believe that's all I have, Your Honor. Thank you, Mr.
Can you redirect?
No.
Oh, hold on, ma'am. Don't get up yet. No redirect.
No.
Can this witness be released?
Yes.
Yes.
Ma'am, you are released from your subpoena. The rule of sequestration had been invoked, but you're now released from your obligation.
Okay. All right. Thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena for,
All right.
sorry.
Ms. Byers.
So what does that mean?
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and the verdict is released.
So does she get the same exemption that Doug's oldest daughter got, where she was released, but not totally, because she has to be available to be called back? But she was allowed to sit in the audience. She was allowed to hear what was going on. So is mom going to be allowed to hear what's going on?
Okay? All right, thank you, ma'am.
Mhm. Thank
You're free to go for now.
No. He doesn't get the same exemption.
All right, State.
State will call Barbara Russell.
This is,
Oh, this way. There you go.
that pisses me off. I believe she's
Good morning, ma'am.
Good morning.
a doctor.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about to 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and allow clear voice into the microphone, it'll pick up everything.
Thank you, sir. And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
Okay. And how long have you known Ashley Benefield?
I've known her since April of 2020.
Okay. And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
All right. And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, oh my God, he came after me, I had to shoot him? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Very much so.
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I
she was
just want to know if
defending
she
her life.
told you. I just want to know what she told you. She did not tell you
Don't say
anything,
anything
correct?
else. That might,
She never gave me any narrative about what had happened.
Thank you. No further questions.
So why-
Sir.
why? Why put her on the stand? Why?
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Give me just a moment, Your Honor.
Of course. Yes, sir.
Any good lawyer would tell her that. And that's
Did there
exactly
come a
what-
time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that,
Objection, hearsay.
I'm asking a question to this witness.
Well, I understand, but if it calls for hearsay, once you approach, so I can hear what the question's going to be.
Yeah, what the question's going to be. Objection before he even finishes the question. Well, I know it's going to be, hearsay. No, you don't know. Let the guy finish the question, then object. Uh, uh, uh.
Identified you. When you spoke to Detective Warren, Justin, you identified yourself.
Correct.
This was a face-to-face conversation.
Yes.
If you were to tell us today in court about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase.
They can read his mind.
As you sit here today, do you have a conclusion?
Objection.
Can he finish the question?
Sustained.
All right, give me a moment.
Good Lord, people. Then why did you put her on the stand if you don't want to hear what she has to say? This isn't the defense's witness. Did they put her and Ashley's mom up there just to get the first digs in? To control what was said? To beat them to the punch, so to speak? Or are they going to try to refute their testimony? I don't get it. I don't understand the strategy here.
I see the pictures that were entered yesterday.
And actually, he has more leeway in cross examination than he would if he had put her on the stand himself. So I think the prosecution made a big mistake. Because he could
Dr.
leave
Russell,
and cross.
you had an opportunity that morning, from what you had to say at approximately 1 o'clock, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21. Picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you on it?
Yes.
Does that picture reflect any swelling to Ashley Benefield?
Objection, as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay. What was different about her?
When I saw her after the incident, there was edema, swelling on the side of her face.
Okay, and did that include her right eye?
It included her left eye.
Left eye, rather?
Yes.
Okay. And when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
Remember, she said she got smacked upside the head, or he said, an opening.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we approve?
Yes.
Now, why did you put her up there? I'm really. She always nods her head like, can you hear this maybe? Do they do that? Oops. I have to be here and then I can do, no. It's not letting me do it this time. Why not? I don't understand. Sometimes I can, sometimes I can't.
Did Ms. Benefield that morning give you any indication that she was in pain?
Yes.
And did you refer to any particular area?
Yes.
What?
Her head.
Thank you.
Redirect.
No.
No redirect. Why the hell did
Can
you
this
put her
witness
up?
be released?
Yes. I'm sorry, no. She is to remain under subpoena. She can be released from the stand.
Ma'am, the rule of sequestration has been invoked by the attorneys, so that means that until you're released from your subpoena or until the jury is discharged, you're not to discuss your testimony in this case with anyone outside this courtroom, including the attorneys. You're not to talk with any other witnesses about your testimony. You're not to talk with any other witnesses about their testimony or the questions that were asked of them. And it's my understanding this may be online, so you're prohibited from watching anything that's going on within these four walls.
Absolutely.
Thank you, ma'am.
Thank
Just
you.
leave the picture there.
I will do so. Thank you.
All right, State.
Judge, the state would call Lieutenant Dan Dickerman. I know he was caught in the line, so I just want to make sure it's it.
It's not letting me in advance. I don't know why though.
Remember, we have an issue here I'd like to take up for just a moment. I don't know if you
He's
want to speak for 5 minutes.
Hold on one second. Approach.
This will be witness number 11. They didn't like me doing it so much. Won't let me go backward either. So I don't know why. Why it lets me do it sometimes and not other times. I don't want to start doing the
So Ms. Farrell affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I did. Hello, sir.
Yes, sir.
My name is Judge Ryder, presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right, however you need it. Just speak in a loud, clear voice, you should hear everything.
Yes, sir.
Good morning.
Good morning.
Please state your name and spell your last name.
Daniel Dickerman, Dickerman.
And where do you work?
At the Manatee County Sheriff's Office
How long have you worked there?
for almost 29 years.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
Okay, so Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay,
Yes.
so you were the senior investigator in that unit.
Yes.
Okay. And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from all the agencies within the county, the Sheriff's Office, Braden Police Department, Palmetto Police Department, and all 3 beach agencies. We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality is a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes. In the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes, for all intents and purposes, the supervisor of the case. He makes assignments. We go out. All the other detectives, we do our respective assignments. We report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes. And then he makes the ultimate decision once he has all the information.
Okay. And are you, as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and the happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you called, were you notified of the shooting?
I was.
Okay. And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing would be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay, and what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile, and that's about it.
And were other members of your unit there at that scene?
Yes,
Were there other members of the unit at other scenes or other places?
yes. Detectives were also sent to our main offices, Criminal Investigation Division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime.
Sustained.
Did you know there was a self-defense element when you got there?
Object the leading. I'll overrule on that.
Yes,
While you were at the scene, were you made aware that the defendant was going to be going to the station?
yes,
Okay. Was the defendant's mother, Alicia Byers, there?
yes,
Did you speak to her?
yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
And did you speak to that lawyer?
Sustained.
Did you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Relevance.
If you want to approach it, explain the relevance.
They don't like it too much when it comes back at them, do they? Oh, well, too bad. It's going to work now. Nope.
Did CPS try to speak to Alicia Byers?
Yes,
Okay. Were you present when
Yes.
Alicia Byers?
yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Did you also assist in executing a search warrant?
Yes, I was on scene
And where was that search warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection, relevance.
What video?
Ring from the
Ring.
scene.
But overruled, I mean, you could say he viewed it.
And in viewing that, did you see any part of the incident that we're here about? Was it captured on the Ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay.
And that's important. Why?
I have no further questions. Thank you.
Pause.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervise and I felt all homicides are murders.
Objection.
Let him finish.
Fair question, Your Honor.
Objection. Pretrial ruling.
Sustained.
You
Ridiculous.
mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside in the back, correct?
That's correct.
With a cage.
Yes.
So she's in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
Okay. So I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Where are you going with this?
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in her 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
She appeared to be. There was a lot going on.
Yeah. Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was that
Hearsay.
her daughter
Please
was dead.
stop
Sustained.
talking.
Unless you'd like to make an argument for an exception, then you can approach.
Rest gesti?
Well, if you'd like to approach,
It's all right, Your Honor. I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay, and that would have included the initial deputies on the scene as well.
That's
God bless
correct.
you.
Good points.
Give me just a moment, Your Honor.
Yes, sir.
Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
Redirect.
Yeah, thank you.
Can this witness be released?
Yes.
Mr. Taylor, can this witness be released
Yes,
from your
sir.
subpoena? Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
Space.
Can we approach?
Why? I really, really, can you tell, don't like the prosecution. I'm. Is it working again yet? Yes. All right. We're taking a break of some kind. Excuse me. So let's see where jury's coming back in.
All right, welcome back, members of the jury. Hopefully no one started deliberations amongst yourselves, talked with anybody outside the jury about the case, did any research on the people, places, things, or legal topics we've heard anything about.
No, sir.
No? All right. State, call your next witness.
State called Stephanie Murphy.
Your Honor.
Yes.
Oh, I guess that one.
Hello, ma'am.
Good morning, Judge.
My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent the letter, that she was retained to send the letter. Now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, was when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
Okay. So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that letter?
To my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
Okay. And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
Okay. And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay. So it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. And so he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation.
This is his eldest daughter by his second wife. His second wife, Renee. And offhand, I don't remember what. I think her name is Ava.
That was changed, and now in Florida, at least, and especially in our circuit, We have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision-making and time-sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be, and of course, it can be also in a paternity case, so parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Miss Benefield for a while. His initial,
Sustained.
Okay. So initially it was not connected with divorce.
right, his priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he, I think, had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question, Your Honor.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So
Okay.
both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the Child Protective Team testifying. And so there were too many hours. And so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did, September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion,
Yes.
overruled.
Okay,
Go ahead.
thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied the petition.
We don't want to talk about what went into that. We just want to know what her ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part.
The second part was on the parenting plan case or the time-sharing case. And so in that, she entered a ruling for a time-sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parent responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay, and
So
how
when
did-
I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
Objection.
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, "Well, of course not, no." And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, "I want to go with you." And he said,
Objection.
Okay.
Narrative.
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Can we approach?
I
Sustained.
agree. And the judge just sustained it, which means he agreed too.
This is one of those situations that's going to take us a few minutes, so I'm going to excuse you back to the jury room. Again, please don't begin the deliberations amongst yourselves. Please don't contact or speak with anyone outside of the jury about this case. Don't do any research on the people, places, things, or legal topics we've heard anything about, but certainly you can use your phones and everything else to communicate.
The court knows is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out, are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context to her narrative in response to the question.
So as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity, with the jury not present, to look and see if there's a standard jury instruction.
I don't think.
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent's statements in that case to He was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
That'll be fine, Ron.
Except for the you are about to hear me, because they've already heard some, so.
And you have heard.
Or want to substitute, you've already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation that's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is, the effect those statements had on Ms. Murphy.
If I may, Your Honor?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony, it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland and about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, are not, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Your Honor.
Response?
Judge, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, that person, this person, I don't know that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Miss Murphy, and telling the
'cause he
jury
was
not to
lying to her.
consider the statements by Doug Benefield as true, but only to establish the context of Miss Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Miss Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. And that way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records, or Judge Moore.
All right, thank you both very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I haven't heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. All right. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling if a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I do have one scheduling question, if it's okay with your honor. We have, after Ms. Murphy, we have 2 law enforcement officers here. And then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they originally scheduled, but they have patients and they're asking if they need to cancel to come early.
I have no idea how long these next I don't know how long Ms. Murphy is going to take. I don't know how long the next 2 witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here? Because he's with patients right now, so I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then 2 other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finish with witnesses around 11:45, unless that very next witness was both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish
Okay.
this morning. I
I'll
don't
just
know.
tell them it's after lunch for now. Thank you, Judge.
Are you ready to bring the jury back in?
Yes.
Defense? All right, let's bring Ms. Murphy in first.
Okay.
Characterizations of observations as opposed to observations. Characterizations of limiting instruction. I haven't heard the parties agree on language. Characterizations of observations as opposed to some of your.
Yeah.
All right, ma'am, while you were outside, I did sustain 2 objections that were raised by the defense. And that is, some of your testimony has been editorial rather than factual, and has been characterizations of observations as opposed to observations.
Okay,
So just FYI, I did sustain those 2 objections.
okay,
Otherwise, we're just gonna keep having questions and answers. I'll rule on objections as we go.
great,
All
thank
right.
you.
Go ahead and bring the jury in. Research on the people, places, things, or legal topics we've heard anything about.
No.
Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed a, gosh, let me think back. It was so many years ago now. A series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I learned that there was a series of complaints filed with.
I'll sustain.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object relevance.
I'll overrule.
So of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object editorialized.
Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective
Objection
Team.
editorialized. How many
Sustained.
times?
So an evaluation was recommended.
I sustained it.
I request an instruction from the board to jurors to disregard the last answer.
Members of the jury, I've sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you of one of those very important instructions. If an objection is made, you're not to guess or speculate as to why it was made. Likewise, you are not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process
Hold
with,
on. Sufficient?
I'm sorry.
Thank you. Yes, sir.
Go
sorry.
ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection.
Basis?
editorializing, not responsive to the question.
Ooh,
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur, I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's you generally a certified family court mediator. And so what it generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation.
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield.
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection. Not responsive, editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not able to. Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Jack's
Maryland.
Speculation as to what the path forward was.
Ooh.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th.
Okay. And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
Oh, it was still Diana Moreland. She was still a judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Yes. Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family court,
Family law, yes.
and you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional Conduct?
Relevance, Judge?
I'll overrule. I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm-
Are you
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
just.
approach the witness?
Yes.
See if this
Yeah, my reading
refreshes
glasses,
your
if that's okay.
recollection as to the date.
I need to get my reading glasses, Mr. J.
I don't know who these people are.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes. The
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Okay.
filed on his behalf.
That
Yes.
you drafted and filed on his
Yes.
behalf.
Correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevant, Judge?
I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations
Okay.
that he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition,
Objection,
while,
pretrial motion.
Sustained.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like to
approach,
approach?
yes,
So pretrial means that they agreed to certain things before the trial began. But if somebody makes reference to something that was a pretrial thing, they open the door to it being spoken about. I had no idea how she opened the door. Ah,
All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11:20 right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch, if you go to a group, that's just fine. You can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere, you hear, just kind of hear in the din of the people behind you something about the case, just let them know, hey, I'm a juror in this case. I need you to stop. If they don't, if they persist, please leave and report it immediately to the deputies. All right, we'll see you back hopefully around 12:45.
Hey, Jerry is leaving, and I'm waiting to see if anything else is all decided, whatever.
All right, you're going to have a seat. The jury's out. Ms. Murphy, we're going to take an early lunch break. I want to remind you that the rule of sequestration has been invoked, so you're not to discuss your testimony or the questions asked of you with anyone, including the attorneys. You're not to discuss your testimony with any other witnesses or talk about what their testimony was or will be. You're not to view anything about this case.
Yes, sir.
All right, we'll see you back here. If you can also be here be back about 12:30.
Okay, no problem.
All right, we'll see you guys back here at 12:30.
Are we going to the seal? Show me the seal. So I know it's official. Excuse me. My doggy will be happy to know we're breaking for lunch. I think we're going to the seal. No, we're not. We're snooping. We're being there it is. That's what I was waiting for. That's the seal. That's what I was waiting for. So, the morning is done. It was only an hour and 37. Okay. It's okay by me. Trying to figure out what I'm thinking and what I'm doing. So there was a lot of objections to narration and editing and some of the other things that she kept doing, which she is Stephanie Murphy, the family law lady, that Doug hired to file the different motions, starting off with, let me see my kid. Let me be a part of the birth and the rearing. What I don't think she understands, and maybe a lot of people don't understand, is those who commit domestic violence, they do it behind closed doors. They don't let anybody else see the side of themselves that they save for the significant other. They don't show that side to anybody else. So her impression of him, in my mind, is skewed, because he only showed how wonderful and nice and compassionate and quiet and reserved he was. It's all an act, because inside they can be seething that their significant other had the gall to try to get away from them. You hear what I'm saying? Everybody else thought he was such a nice guy, except for the neighbor who called him strange. And the other neighbor who caught him at least once peering through windows at 9:30, 10 o'clock at night. Yeah, see what I mean, Vern? But that attorney had no idea what went on behind closed doors and why she kept trying to file motions to restrict what he can do, especially with the child. She didn't trust him. If he could knock out a dog, if he got pissed off at that child, what would he do to her? You see what I mean, Vern? So there was a lot of objection, Your Honor. I still don't understand why Alicia, Ashley's mom, and Dr. Russell, the clinical social worker, why they were brought on when they, and the point is what? They did more for the defense than they did for the prosecution, in my mind. I really don't understand understand the strategy of the prosecution. I clearly see the defense. I clearly see the relevance of a lot of things. I clearly see the abuse. If you've never been in that situation, God bless you. Thank God. I hope you never experience it. You never ever see it. I hope. Sorry, I was distracted by the film over my eyeballs. But I hope you never experience it. But as somebody who has experienced abuse, I see all kinds of red flags. So either Ashley is brilliant at setting stages that are inaccurate and making things look like they aren't, or she suffered this. And she was fighting tooth and nail to get away from him, to keep him away from her daughter. What was the other thing he did besides firing his weapon in order to get her to shut up? He knocked the dog out, threw a loaded weapon at her. And the intimidation factor. He was such a small man. He wore small shirts. His waist was only 30. He was a little guy. I wonder what size Ashley is. So you got this little guy, and then you've got Ashley. Big guy compared to Ashley. But not only that, he was ripped. You remember the photo of him? He was ripped. He had all kinds of muscles. He also knew about not hand-to-hand combat. What's it called? I don't remember things. His daughter knew Taekwondo. His oldest daughter, I should say, knew Taekwondo. Let me get back to the daughter. Eva. Is that right? Yeah, she's a black belt in Taekwondo. Close quarters defense. She knew about that. Her daddy knew about that. Ashley fired at him. Did he run? No. He was ready to come after her and grab that weapon out of her hand with close quarter defense. And what was he going to do after that? He was seething. He was claiming his rights as her husband. He said it. Yeah, such a good, quiet guy. That's what they do. That's how they get away with it. That's why I'm suspicious of the death of his long-standing wife, as the cousin kept referring to her. Long-standing? I think that's what it was. Doesn't matter. But she was found face down in her bed. Blood everywhere, if I remember correctly. What was I looking up? Something about the cousin. Oh, how he kept referring to Doug's second wife. I can't find it offhand here, but it was something about long-standing wife. Long-standing. And the only thing I can figure why he made that distinction, his first wife, he was married 3 times. First wife was only 6 months, I believe. And that's when he was like 20-something. Then he was married to Renee, who he had daughter Eva with. He was married to her for like 15 years, something like that. Long standing. Was she also long suffering in silence when nobody was looking? And suddenly she dies, and only 9 months later, he's on the prowl, looking for somebody and changing his interests and likes and stuff to match up with Ashley to draw her in. How much older? 30 years older? He was 54, she was 24. He knew what I was doing. He was a manipulative bastard. Read my lips, I said it. I'm going to let you go. Rewind, check things out, come up with your own conclusions, and we'll find out more stuff later on, after lunch. So we'll be back after lunch, and we'll take things from there. So until then, take care, and God bless.